To moderate the next panel is Eileen O'Connor from the Lawyers Committee for Civil Rights Under Law. Eileen serves as senior counsel in the Legal Mobilization Project, where her work focuses on litigation of cases under the Voting Rights Act and Section 7 of the NVRA. She also supports the Election Protection Program and works with the Voting Rights Project's election reform efforts across the country. And Eileen, I'll turn it over to you.
Thank you. Yeah, everyone turn your mics on. All right, thank you, Katie, and thanks to everyone for sticking around. As various people have said already today, it's very inspiring to be in a room that has standing room only at the moment, talking about these issues. And I think, as Katie mentioned, the second panel is on defending voting rights through state and legislative advocacy, which I think is a perfect complement to the discussion that we had this morning that focused more on litigation in state courts and using state constitutions. Something that was said on the panel early this morning that really struck me, Professor Tolson said that the decision in Shelby forced voting rights advocates to be more creative. And today, you're lucky to be hearing from a panel of 4 people who I think have been very creative and very innovative in pushing for reform and expanding voting rights in their own states and in states in their region since Shelby and since before. So I'm very familiar with all of their work, but I will make sure that I get their titles right as I introduce them. And then I've just asked each of the panelists to start off and describe 1 or 2 of the successes they've had, and of course any challenges that they've faced in advancing some of these reforms that they've gotten through, and then we'll have more of an interactive discussion. So on my far left is Kathay Feng, who's the Executive Director for California Common Cause and the National Redistricting Director for Common Cause. Next is Tram Nguyen, who is at New Virginia Majority. She's the co-executive director there and wears many hats, but is, as I know, being in DC, is in Virginia the go-to person for voting rights. To my right is Bret Healy, who is a consultant for 4 Directions, which is a Native American voting rights advocacy group, and he's worked in Minnesota, South Dakota, Montana. Is that about it? Nevada, Arizona, all over. And then last but not least, Marissa Liebling, who is Program Director and Legislative Counsel at Change, Illinois, where she runs Just Vote, a coalition of political reform, civil rights, and community groups. And I, of course, also have to mention, Marissa was formerly at the Chicago Lawyers Committee, and I got to work with her there. So there are our panelists, and I'll just start again with Kathay and let her start it off.
Sure. Thanks so much. I'm going to rearrange my presentation a little bit and pick up off of what Jason Carter talked about. And in many ways, the issues that he highlighted as being paramount really are the core of what Common Cause is working on, whether it's money in politics, making sure that the redistricting process is fair and transparent, and also ensuring that our elections are accessible and truly inclusive. So I'm going to talk about my favorite issue, which is redistricting. And I fell into this issue, I have to admit. Maybe 15 years ago, I hadn't really thought about redistricting at all, barely thought about the census, and was organizing Asian American communities to participate. And the ugly reality was that in California, we had a process that was set up that was intended to be a public process for show, but in reality was really something that was done behind closed doors, where the incumbents went and drew the lines that they needed to for whatever nefarious purposes they felt comfortable expressing. And in many cases, they felt very comfortable expressing what their motives were. Certainly I have phone calls from sitting assembly members, this is in 2001, who would tell me, Kathay, you're not going to put another effing Asian in my district. And when I say effing, she used the full word. And I think that there's substantial evidence that came out in recent redistricting processes where the legislature had control where that ugly mix of race and politics reared its head and had devastating impact on minority communities. What I took away from that 2001 process was that in so many ways the law has been eroding under our feet. Even though we had the Voting Rights Act, the courts were increasingly holding in case after case that they were going to give extreme deference to the legislature to be able to draw lines that were protecting incumbents, because that was a traditional redistricting criteria. And so the only way to rebalance that was to really think about how we could change the law and change the process by which those lines were drawn. And in California, as folks may know, this was a long process. We actually negotiated with the legislature for 3 years, thinking that the incentives were there between the Democrats and Republicans to potentially create an alternative process. But much like Charlie Brown running up to the football, after 3 tries, 3 years, we realized, or maybe I realized, I'm a slow learner. But that football is always going to be pulled out from under us. So we embarked on an initiative process. Oh, thank God, there's not an echo. It was undermining. I couldn't even think. Anyways, and so we went to the initiative process, and truly after much negotiation with a lot of organizations leading up to this, because we'd had 3 years with the legislature, we put together a proposal for an independent commission. Only this time, because we were not negotiating with the legislature, all of the concessions that we might have made to give them a greater role were taken out. This was a truly unusual coalition. As Jason Carter says, there are lots of reasons why organizations come to redistricting reform. Certainly, we worked a lot with a lot of Republicans, chambers of commerce, sheriff's departments, ACLU, and ACP. So it's not the groups that usually find themselves in the same at the same dinner table. And what we found was that there was a fairly positive response from voters that they also agreed that fundamentally redistricting should not be done by those people who have a direct interest in what the outcome is. So they were willing to hand it over to a commission in 2008, and then 2 years later in 2010, we passed the second initiative that gave the commission responsibility not only for drawing state lines, but also for drawing the congressional lines. Huge. Let me just say that there are about a dozen states that are currently looking at similar redistricting reforms. They're pursuing it using different methods. So in states that have the initiative, obviously they're thinking about this through the initiative route because it is so difficult to pass this as legislation through a legislature that you're fundamentally taking power away from. But there are also states like North Carolina, like Ohio, that worked redistricting reform through their legislature or are working the reform through the legislature as bills. And it really does require cobbling together a huge coalition of unusual allies in order to pass this, because you are up against the political establishment that wants to preserve career protection, if not lifetime job protection. So in many ways, what we're up against is against sometimes insurmountable odds. I would just like to note that the third way that many states have found to open up the process, or at least to put into place alternative systems, is through litigation. And Tram, you may talk a little bit about this, but certainly in Virginia there's been successful litigation, and it's forced a conversation in Virginia about whether or not the legislature should continue to draw the lines. Just a point of note, so we are currently waiting for the Supreme Court to come down on a case involving the Arizona legislature, which is challenging its Arizona Independent Redistricting Commission. It's the only other commission that was created through the initiative process that also fundamentally takes that power away from the legislature. And if we take the legislature interpretation of the Elections Clause to mean that only the state legislature may determine the time, place, and manner of congressional elections, it not only could undermine the creation of these commissions, it not only undermines that, it could potentially also undermine the ability for citizens to use the initiative process at all to pass election laws, and it may also go so far as to change the use of many election laws to that are employing alternative bodies, whether that's your Secretary of State, your counties that are running elections. I mean, think about how much we devolve to other bodies to carry out our elections. It's not like the legislators are sitting there handing out ballots at every election, right? So it's a crazy theory that they've put forward, but certainly one that we're watching very closely and very involved in. The second thing that I just want to quickly talk about is the National Voting Rights Act. So this is a law that was passed in 1993, and you know, it's funny because it had its heyday right after it was passed in the 1990s, and it sort of languished for a while. But there has been a recent flurry of activity in many states to look at the National Voting Rights Act and what it requires in terms of requiring government agencies, whether it's the Department of Motor Vehicles or those that are providing public services, to integrate voter registration into their provision of services. And just a quick highlight, so in California, when we joined the Obamacare and created the state healthcare exchange, part of that process was to also create an online registration process. When this law was passed in 1993, we really thought about National Voting Rights Act requirements as putting out a box with paper forms on the counter of the DMV, and that was good because that's what you could do. The law has now evolved, I think, in many jurisdictions to allow for us to think about how that voter registration process really needs to be integrated in every possible way. And so to the extent that states are now pursuing online voter registration and they have a healthcare exchange, the possibilities could be limitless. So certainly in California, we have negotiated, I shouldn't say we, let me not take credit for some of our partners like ACLU, Southern California, have negotiated a requirement that not only should the healthcare exchange provide a widget on their website to allow people to register to vote, which really is only drawing a handful of people, but every time somebody uses that system, that it has to ask them if they would like to register to vote, and if they say yes, it directs them to the online voter registration system, and it will eventually pre-populate that system with, pre-populate that online form with information about that voter so that their name, their address, and other information that the healthcare exchange might have is put in already. Just the last note, so what's the potential for integrating these systems? The Presidential Bipartisan Commission on Election Reform identified online voter registration as one of the key pieces of reform that they would recommend that had huge bipartisan support, both because it serves as an efficient entry point for voters, it eliminates a lot of administrative burden, and it saves money for the states and counties that are carrying it out. In California, in 2012, when we implemented online voter registration, in 1 month alone, we got 800,000 new registrants into the system. Of that, it was racially and ethnically diverse, but 1/3 of them were under the age of 25. So we are really bringing in that next generation of voters that have not been participating up until now. So when we think about expanding the franchise and ensuring that we have 100% participation instead of the paltry 10, 15, if we're lucky, 23% participation in a lot of our local elections, it really suggests that there's enormous potential by working through our state processes to implement these systems. Thanks.
I turned it off because I thought I was causing your echo. I wasn't sure because I don't think there's an echo now. So thank you. I really appreciate being here and being able to talk a little bit about our experience in Virginia. Like Kathy, I am going to also rearrange what I was going to talk about. I'll start by talking a little bit about Virginia's voter ID law, and then I will touch on the redistricting
what's going on with redistricting in Virginia. So first, a little bit about our organization, since I don't think very many folks are familiar with us. We're not your typical civil rights organization. So we were founded in 2007 after the nationwide immigrant rights movement, when millions of folks across the country marched and took the streets thinking that we were going to pass comprehensive immigration reform in 2006. Well, that didn't happen, and it was unfortunate, but it didn't happen, and our analysis, our founding board of directors, part of that analysis was because new Americans, immigrants, Latinos, Asian Americans weren't voting. We weren't voting at a high enough rate that politicians would actually be paying attention to our needs and what issues were really important to us. And so we set out to register new American voters in Virginia, to engage them, turn them out, get them to the ballot box, and to basically change the conversation, especially in Virginia, and as more and more organizations were doing this across the country. So right around the time that we started to really ramp up and had great successes and increased Latino turnout, increased AAA turnout in Virginia, we also saw an onslaught of legislation and bills that would basically suppress the right to vote, particularly aimed at minority voters and voters of color. And so while we were founded around immigration reform and a lot of social type of issues, we also knew that we couldn't just let the voting rights issue stand aside, that we had to take this on too, because fundamentally if our right to vote, if our folks were being restricted and their access to the ballot box was being restricted, then we weren't going to affect any change anyway on any other issue that we cared about. And so we took on this mantle of protecting the right to vote in Virginia, and have since formed a coalition of a lot of like-minded organizations that we chair, including a lot of the national civil rights organizations, the Lawyers Committee, Fair Elections Legal Network, Advancement Project, and then some local state groups. And so that's sort of what we're, why we're in this, because voting rights matters, in particular as Selma is now. It's not a black and white issue entirely anymore. It's encompassing for all people of color. So there was a lot of talk this morning around ID laws across the country, and in Virginia was no different. We've been fighting, or we were fighting Virginia photo ID laws since 2010. And year after year after year, we were fighting it in the state legislature. And we used a lot of the arguments from the Georgia and the Indiana cases saying, well, no, you can't do this. It's going to cost the state a lot of money because you can't charge for the IDs. And if there's a birth certificate requirement, you have to pay for that. And we made all kinds of legal arguments. And we did such a good job that in 2013, in that session, they basically had a bill introduced that was very expansive. It was just it was going to be free ID for anybody. Didn't really put a lot of restrictions on it, and so it sailed. They basically took all of our arguments and addressed them in a bill that was passed and signed into law by a Republican governor. So, okay, maybe we shouldn't have done such a good job about arguing those legal arguments. And so here we were. And so what do we do at this point? There weren't a lot of details in the bill, and so our coalition of organizations decided to take a look at administratively what could we do. The State Board of Elections was authorized to promulgate rules and regulations around photo ID. We had a lot of lawyers, before we went that route to sort of mitigate the effects of our photo ID law, we had a lot of lawyers look at it and just to analyze, is the law that Virginia passed restrictive enough that it's something that we want to take up in the courts? And consistently, every single lawyer that we've talked to said, well, you don't have a strong enough case. This isn't one that we'd want to take up to the Supreme Court. So then we looked at our state constitution grounds and said, okay, is this something we want to, litigate in the state courts? Well, your law's pretty, not so bad. So I was like, okay, well then, we're going to go the administrative route, and we're going to make sure that the rules that the state puts in place has as little effect as possible on Virginia's voters. And so through that advocacy, working with both the Republican administration, because that was when it was under Governor Bob McDonnell that the law was passed, and then now with the Democratic administration, we were able to basically make sure that Virginia's photo ID law was just not as restrictive as in other places. So in Virginia now, if you don't have a photo ID, you can go to any registrar's office, doesn't have to be your own registrar's office, and basically just sign a form saying you don't have one. You don't have to, it's not an affidavit, it's just a form saying I don't have a photo ID, I want one for free. They'll take your picture, you get a photo ID, and you're done. If you show up on election day without a photo ID, you can get your picture taken that day and be able to vote. We passed this session a law that actually got signed last week, that your name doesn't have to match what's on the rolls with the photo ID. It passed a Republican-controlled General Assembly too, mind you. So we're trying to basically mitigate as much as possible the effects of photo ID, especially as we're seeing across the country, state by state, that we're losing this battle on ID. We'll see how the courts rule in Wisconsin and all of these other cases, but essentially, the courts, it's a mixed bag, and so in many places ID is here, and it's here to stay, and in Virginia, certainly we felt that was the case. And so we made sure that, all of our advocacy was geared towards mitigating as much as possible the effects of photo ID. Now, obviously we don't like it. We don't like the law. We think it's completely unnecessary, and actually the way that it's set up, it is unnecessary, especially if, you turn up to vote, you take your picture, you can turn around and say, here's my ID now, like without any proof of identity, so it's silly. Of course it's silly. And so we're hopeful that one day they're going to take a look at the state budget and say, well, we're wasting all this money issuing these free IDs, and there's really no point that we'll be able to get rid of it. So that's one of the strategies that we've used, is just mitigation. Especially as we take a look at the laws that have been passed, and that there was a strong legal court challenges that are viable. And then the other thing, since we're talking about court cases, and Kathay brought up redistricting, it's also a very hot topic. We've been in Virginia trying to pass redistricting reform for a number of years. We've been trying to pass an independent redistricting commission to basically no avail, right? But this past year, in I think it was October 2014, a federal court in the Eastern District ruled that Virginia's 3rd congressional district was unconstitutional. It packed too many African American voters into this 1/3 congressional district, and it basically diluted their vote. And so the court basically told the Virginia General Assembly, you have to redraw this map, and you have to do it by April 1st. And because of the Supreme Court case pending, of course, they've given us an extension to September 1st. But because of that ruling, a second court case was filed on Virginia's state house maps, state legislative house districts, saying it's the same argument. There are 9 state legislative districts, house districts in the Hampton Roads area, huge African American population, all packed to create these majority-minority districts that basically diluted the African American vote. I think because of these court cases, and essentially because of that ruling, there has been a groundswell of support around redistricting reform, and people are having conversations about it in a way that they haven't before. So we had a couple of bills, our session's over, it was January and February, but we had a couple of bills that were introduced that for the first time actually made it out of at least the Republican-controlled Senate. The House is a whole other story. We've got a years-long strategy on that. But essentially, 2 bills passed. One bill that dealt with redistricting criteria. So essentially, nonpartisan, independent redistricting criteria around, what these districts ought to look like. That passed unanimously for the Republican-controlled Senate. And then the Independent Redistricting Commission passed with 2/3 majority of the Senate as well. And so you could see that there's this bipartisan support around redistricting reform that we hadn't had in recent years. And so I think there's a lot of momentum, and we're going to try to take on that momentum and carry it through. We expect the court rulings to stand, and that Virginia will have new maps in 2016. So there would be special elections in 2016, especially for our state level, which I don't know if folks know, but in Virginia we have off-year elections. So we have an election every year, which makes it really fun. But all of our state level elections happen in an odd number year. So it also makes, with turnout really low, it also makes it really difficult for voters to participate, especially at the state level. And so for us to have a special election in 2016 for state races, I think it also changes the conversation entirely, the dynamics of the politics in Virginia entirely. So that's something that we're looking forward to as well in 2016.
Okay. My name is Bret Healy. I'm a consultant for Four Directions, Inc., which is an organization that O.J. and Barb Siemens, members of the Rosebud Sioux Tribe in South Central South Dakota, had started with me back in 2003. Prior to that, I'd ran the South Dakota Democratic Party in the 2002 election, in which my old boss, Senator Tim Johnson, won by 524 votes with a historic turnout in Indian country, carrying him over the line. Of course, folks that didn't like to see him win suggested that it was won with dead Native American votes and fraud, and certainly the South Dakota legislature responded very quickly. We had one of the early rounds of a photo ID law that was implemented going into the 2004 election. As you know, across the country, voting, while the restriction on who gets to vote is certainly there for the folks that everybody agrees should vote, I guess, has been made easier and easier. And in fact, in South Dakota and in Montana in 2004 was the first election that there was no excuse absentee voting. So prior to that, you had to either tell a small little lie that you were going to be out of the county on election day, or you had to have a reason that you were needing to cast an absentee ballot. That changed for that 2004 election. It was the first election that, in a nonpartisan way, Four Directions operated, and we put together a get out the vote on Indian country in June of 2004 in a special election, and thought we did a pretty good job, but as the after action review is how could we do better, and that is when we lit on the idea of being proactive. As Dale Ho talked about earlier today in the New Jersey situation, we actually said, well, we should make it easier to vote for Native American voters. And with that opening of the restriction on absentee voting, we concentrated on two of the Section 5 counties in South Dakota, the Pine Ridge and Rosebud Indian Reservation, and went to the county commission and suggested, hey, we've got donors who will pay for the cost to actually have a voting official, an election official on the reservation. Now, those two counties happen to be unusual in that they don't have a county courthouse. And to level set for the room here, Indian country is a bit different than other communities of color in that they have tribal governments. And certainly at the local level, that puts a couple of more issues in play for the majority population. They think, well, the Indians have got their tribal government. They shouldn't really be voting in this county, state, and federal government. They got their own election. And secondly, because Indian country provisions in the Constitution of not taxing tribes and not taxing income earned by Native Americans on a reservation, these Indians don't pay any taxes, and therefore they shouldn't be voting in a county commission election. And so you have a couple more things that make it that much tougher. These border towns are tough. Notwithstanding that, we were able to convince them, and we covered the cost of that extra election expense, and we nearly tripled turnout from one presidential election to the next in 2004. That was Tom Daschle was losing that race statewide in a very closely contested election, but Native participation in those three satellite voting offices, there was a third reservation that actually Brian Sells, when he was at the ACLU, had found a county in South Dakota that the Native voting population of basically one white person was worth 16 Native Americans in a county commission race. They got that changed going into 2004, and we had a satellite voting office because they also had to pre-clear things. We had to get those three changes pretty clear. That's as a matter of history. Relative to this panel, we have continued on and off to try to expand that opportunity, sometimes with political efforts at the county commission level, sometimes to success, and sometimes ultimately ending up in court. We tried the same approach in Montana in 2012. Hey, we'll cover the costs. Well, the Secretary of State said, well, we can't do this in Montana. And the county said, we aren't going to do it, even if you provide the money. So that ended up in court, and I'm not going to touch on that because that became a many-splendored thing, and actually looking to work with Native American Rights Fund and others to perhaps do the follow-up. But at the end of the day, I will tell you, I suspect that we're majority Democrats in this room, just a hazard to guess. However, unfortunately, when it comes to Indian country, it is still a bipartisan opposition to Native American rights. In Montana, it was a Democratic Secretary of State 2 of the 3 counties we were up against were run by Democrats. Now, switching into the more cooperative model, if you will, South Dakota and Minnesota in the 2014 general election. Minnesota in 2014 went to a no-excuse absentee voting. We've had a long-time relationship with the White Earth Band of Ojibwe, so we worked with Chairwoman Visner, and the Secretary of State said, hey, you ought to have an equal opportunity on reservation for Native Americans to participate in an in-person way to vote. And we were able to work with those counties to do so, but in large measure because we had good partners, and Eileen is one of those good partners. The Lawyers Committee became a legal muscle because even with the very advantageous approach, we tried it again. We'll pay for the cost. We've got donors that will pay for it. They were still pretty hesitant, and in fact, one of those counties said, nope, we're not going to do it. We were able to go back to them and suggest that they might just face litigation risk, and that maybe they might want to reconsider, and that county did, and we were able to, with the other counties, find some good people with goodwill, and ultimately we opened 5 of those satellite offices in Minnesota for the 2014 general election on reservation, open not all for the same number of days and hours, but equalize that opportunity. The other thing I will tell you, Native Americans living on reservations, at least in the Midwest and West, tend to be much poorer than the general population, much less access to vehicles, and because of that constraint of those border communities, sometimes not a very friendly place to be at that county courthouse. So that opportunity to vote on the reservation makes it an incredible difference. Switching to South Dakota, if you will, and our further efforts there, both in a litigation sense as well as cooperation. 2013, we went to the state elections board. We were working with counties saying, hey, South Dakota happens to be one of the states that still has about $10 million of HAVA money. They didn't spend much of it, and we made the case that much like they had in a litigation had to provide one of these satellite voting offices on the Pine Ridge Indian Reservation, that they should use those funds for other counties so that they could provide equality of voting opportunities to Native Americans living on the Jackson County portion of the Pine Ridge Indian Reservation, the Dewey County portion, or in the tribal capital in Dewey County, South Dakota, which is the Cheyenne River Indian Reservation, and in Buffalo County, South Dakota, the same county that when Brian was at the ACLU found that 17 or 16 to 1 ratio of voting power, having a satellite there in the tribal capital. We thought it made a lot of sense. The money's there, it's federal money, it's Help America Vote Act, and of course the election board, chaired by the Secretary of State, voted on a 4-3 basis. No, we won't do it, we can't do it, because we're not sure how the Election Assistance Commission will view such an action, and we're going to have to write to them. Of course, at that time, the Election Assistance Commission was a dead letter. Not a single commissioner, they couldn't rule on anything. So a couple months passed by, we used a lot of public relations pressure, and finally the Secretary of State announced that he was forming a HAVA task force to rewrite the state HAVA plan. Rather than throw rocks at it, we decided we'd better participate, and we did. We had 4 HAVA task force meetings, and we articulated basically a plan that, a clearance mechanism, if you will, a method of proof, as Jason had talked about, of what it would require for that HAVA money to be used. We actually adopted a formula that came out of a DOJ expert out of the wandering medicine case in Montana, that you base it on poverty, access to vehicles, and how far the tribal center of population is from that county seat. Some of these distances, folks, in Indian country are tremendous. In the wandering medicine case in Montana, 120-mile round trip from the tribal headquarters to the county seat. So those distances are not trivial by any stretch. We were able to convince everyone in that task force, that included every one of the election board members, that our plan was the right one to do. The Board of Elections adopted it, flipped it up to the Election Assistance Commission, and of course, one would expect that those 3 counties in question, that every one of them would do it. You would be wrong. The Buffalo County case, they just said, no, we ain't going to do it, and we'd even gotten them to agree 3-0 on a county commission vote before we had the HAVA money lined up, that yeah, if you get the HAVA money, 4 directions, we'll do it. Well, they changed their mind. They weren't as ripe for a litigation play as the other county, which was Jackson County. It's a county that is 50% Native American, 50% white. It is split by the reservation boundary. All the Native Americans tend to live on the south side of that boundary, and most of the whites live on the north side. And even with have the money, their answer was still, no, we're not going to do it. And so at that point, Lawyers Committee initiated action, and they, to avoid a preliminary injunction hearing, agreed to have limited satellite voting on the reservation in the community of Wombly, which is actually a bigger community than the county seat. And that thing is still in live litigation. They are still arguing that they don't have to provide equality to Native Americans as long as there's a way to vote for Indians. That's good enough. So that thing is still in litigation. The third of those three counties, however, was the very proactive gold standard, if you will. The Cheyenne Indian Reservation, now for 2 elections in a row, in 2012 without any HAVA money, and 2014 with HAVA money. They have had the satellite voting office right in the tribal capital and actually deputized a tribal official to serve as a deputy auditor to conduct that election. So a tremendous level of trust has been built, even with the backdrop of elections out in the west of a lot of allegations of fraud. That has come to pass, with Jackson County now being a further litigation matter, and as we go forward. I will close with, we see these opportunities elsewhere in the West. Certainly had conversations with Joel Williams here from the Native American Rights Fund about going back to the Montana side of this thing. We won't go into all the detail there, but there's more work to be done there. There's 7 reservations in Montana. We also see this as a very active potential play in Nevada and Arizona. In Nevada, there are actually tribes and reservations that there's not even an in-person place to vote on election day. They have forced everybody to mail-in balloting only, and that decreases turnout in Indian country without exception. We've found the same in some places in Arizona, in fact, where early voting locations have been closed, always for budget reasons, is the exposed reason. We've exposed that in other jurisdictions that even when we put up the money, they really don't want to do it. They'll find other reasons not to do it. And then lastly, we also think that from some at least initial analysis, in Nevada and Arizona, it probably fits even some rural, isolated Latino populations that have the same barriers, if you will, to Native Americans in terms of not an in-person place to cast a ballot. So that's it.
Great. Thank you for having me here today. So in Illinois, like many of these other states, we have a lot of exciting things going on amongst our coalition and coalition members on a lot of these political reform ideas, including redistricting reform and that sort of thing. But I'm going to primarily talk about 2 recent reforms that we have achieved in Illinois. Election day registration and online voter registration. And just a quick note, we generally say election day registration, even though I know in many other states same day registration is often the term used because we already had a fairly robust same day registration program during the early voting period. But it was really missing that key elemental piece that on election day, if you have problems with your registration or need to register, that you should have an opportunity to do so and to cast a meaningful ballot. And in Illinois, we certainly have not faced credible threats. It's certainly always introduced from restrictive legislation, but it's still certainly quite a fight for any good, expansive laws. And I'll note that I am actually from Texas, so I never thought that I would see myself or kind of be a Midwesterner, if you will. But I've really enjoyed working in states like Illinois because with the opportunity to pass good, expansive voting rights laws, I think it's important for the voters of the state, but it's also important to sort of counter this narrative and trend of restrictive legislation sweeping the country, and as a preventative measure, should any of this legislation that's more restrictive get through. To provide a little bit of context in Illinois, up until this very last election, there was a Democratic majority in both chambers of the General Assembly as well as our governor. But the Speaker of the Illinois House, who has been in power for many, many decades,
really is sort of the key to power, and there's really no passing anything in Illinois unless you have the speaker on board. And when we first approached them about election day registration, we were told that it was a hell no. And over the last few years, we kind of got to a soft no, maybe, and eventually to a yes. When we were working with leadership and with lawmakers on this, we really tried to emphasize the potential to, of course, increase overall turnout in the state, but also to increase minority turnout amongst young voters, and in general, the kind of rising American electorate. And we backed it up with data and figures and all of that good stuff. And so by late spring of 2014, with a very competitive statewide gubernatorial race pending, the General Assembly kind of finally seemed willing to say, hey, let's give this thing that might increase turnout a shot. And there were still many concerns about how it would actually be administered, about voter fraud and that sort of thing. So we were able to compromise and get a pilot program that was just in place for the November election in limited locations and with provisional ballots. So sort of not our ideal law, but something to get the ball moving in that direction. Like I said, it was in limited locations. It was primarily in clerks' offices throughout the state, but there was a formula for larger municipalities as to how many sites they would have to offer for EDR. And there's about 1,500 polling places and over 2,000 precincts in both the city of Chicago, which is a separate election jurisdiction, and in suburban Cook County. Suburban Cook County was willing to do 13 EDR sites, but in Chicago we were successfully advocate from 4 up till 5. And part of that was there was a lot of skepticism that this first time around, it being in limited locations, like, are people really going to use this? Do people really need election day registration? And so we really worked with election officials to make sure they were advertising it. We did our own outreach. But we were a little bit concerned that we want to pass a permanent EDR bill, and if there isn't a compelling, overwhelming number of people using it, how do you make your case that this is something that's necessary? And so we came up with a whole strategy to go to polling places and collect the real personal stories from people using it, which was amazing. We did gather a lot of those. But as it turns out, not surprisingly, people need election day registration. And in Chicago, because there were such a limited number of sites, there were lines 5 hours plus. People waited in those lines, and it really helped show these aren't the lazy voters or just waiting till the last minute. People waited for 5-6 hours in line. The election was already declared, and someone cast their last ballot at an EDR site around like 2 or 3 a.m. And so that kind of turnout, I think there was over 9,000 people that used it in the state in this very limited trial. Was really a blessing and a curse. It was great because it gave us the evidence we needed to show that this was really important for voters, but of course it raised all these questions about how do you administer this? Is it complicated? Voter fraud issues came up again. And so we really pushed to get it out in the media and use this as a framework to prove our case. And so right after the election and veto session, we pushed that now is the time to just get this done. The Democratic governor, who had in fact been very supportive of voting rights issues, lost the election, so we just weren't sure what the incoming governor, who's a Republican, he's tacitly supported things like EDR, but there wasn't clarity about what would happen under the new administration. And beyond that, because we wanted to fight for it in every polling place, we really wanted to give election administrators time and leeway if this was going to happen in 2016 to have good processes in place. I think there were 2 real key elements of our success as a coalition that I will highlight briefly. One is really building relationships. As I said, and I suspect Illinois is not the only state like this, relationships with legislative leaders is really, really critical for us. And we work with them on online voter registration, on the implementation of OVR, and then on the Illinois Voting Rights Amendment, the Right to Vote Amendment, which I'm also happy to talk about. And through that, very strategically and carefully built relationships, in part because in Illinois, because of the very inherently political nature of these things, it impacts the electorate. Virtually every election bill is passed in an end-of-the-year omnibus that moves very quickly. It's pushed through committee, and most rank-and-file legislators don't have a really clear vision of what the language is going to be. And so we've eventually gained a place kind of at the table to be, whether or not we like the process overall, but to at least have a seat in the drafting and review process and have some say. The other thing that was really helpful was having a strong coalition. And one of the things we really worked to do is bring civil rights attorneys together with political reform organizations, together with grassroots organizing groups that all play a vital role together. And our organization is really founded on the principle that you have to include base-building organizations, people that are really affected by these things, to get involved in these kinds of campaigns, both because there's real power there, but because we should be responsive to our communities in doing this. And I think that was really effective. We got more people to listen because of that. And in the drafting process, ultimately, we were able to get it in all polling places, but we had to compromise, or we got it in most polling places. If you're a jurisdiction under 100,000 and without e-poll books, you can opt out. But we were able to get it without provisional ballots, and so it's going to be with regular ballots as well as no height and ID requirements or anything like that. And there were lots of other great elements of the bill that we helped fight for and support that I'm happy to talk about. Expanded early voting hours, registration and early voting on college campuses, agency registration modernization, which we've addressed a little bit up here, and joining things like ERIC, the Interstate Data Sharing Program, to identify more eligible voters. So it was passed in the December veto session, signed into law in January, and so now we're, of course, already moving to the next phase when we're hearing lots of concerns about resources and costs and how the heck are we actually going to do this from election administrators, and the same old fraud arguments. And so there's a lot of concern that they need e-poll books and these other things that are going to be expensive. And that kind of takes me to my next point, which is implementation is so crucial in all of this. Right when we passed the online voter registration bill, we, as our coalition, and I was actually with the Lawyers Committee at the time, but we took a lead in drafting a bill, or a letter signed by many coalition partners saying, here's some straightforward recommendations that we'd like to see. I don't think anything that we were asking for was an audacious demand by any stretch of the imagination, but we were certainly met with some hostility. Like, let us do our jobs. Who are you to say, or tell us what we should be doing? And so we wrote lots of formal letters. Not surprisingly, when we copied key lawmakers, we tended to get more of a response. And we also got the governor's office involved again. The then governor was very supportive of these things, who brokered many meetings and helped facilitate us being able to be involved in the process. So we had to fight for things like Illinois is covered under Section 203 for translated election materials. And originally we were told, well, that's county by county. We don't really have to do that as a state. We finally got them to recognize that they did. I think they said they were only going to do Spanish. Then we got it expanded to all the languages. We had to fight them to not just use Google Translate, etc. It's true. Wow. Another thing we had to fight for was just, unfortunately, as the system is now, it's batch processing. So even when you enter all of your information, by the time it kicks over to the Secretary of State's database to check, it takes up to 24 hours, so you're not instantly notified. And they said if people do not provide email addresses, which is totally optional, they were originally not going to tell anyone that they were not successfully registered, obviously amounting to all sorts of potential problems. And we had to fight for things like, unfortunately, as it is now, the online voter registration requires that you have a state ID number or driver's license number to put it in to match and put your signature. And we had to really fight to say, okay, but you need to make it really clear on the front page that if you are an Illinois resident who doesn't have a driver's license or a state ID, here are all the other ways that you can register and vote, and it doesn't mean that you are not eligible to register. So I think it's really being cognizant that we have to provide oversight in all of these things to make sure that, it's one thing to pass a good law, it's quite another thing to have it implemented in a way that's really meaningful and really does fulfill the promise of enfranchising the folks that we are directing these reforms at. In the drafting process too, I think it's just worth noting in the pilot for election day registration, the law was changed to say instead of having same-day registration sort of early ending before the election, it would be available through the close of the polls. Well, some creative election jurisdictions decided that through the end of the close of the polls meant that we could offer it at 10, 11 a.m. on election day until the polls were over. So again, we have to really monitor how these things are implemented and be careful, I think, with our drafting. And so, just with OVR, we're looking at how are the best ways that we can make recommendations about best practices, about resource savings and that sort of thing to have election day registration implemented effectively. It will be even more of a challenge because Illinois is one of those highly decentralized states, so it was one thing to work with just the State Board of Elections being resistant, but we have almost 110 different election jurisdictions that all have a significant amount of leeway in how they implement these things. And so we're working on that, and then because this was a relatively big election package, we have plenty of ideas, and I'll talk about it. We're working on other things for really kind of larger voting rights and political reform measures going forward. But in the meantime, we still want to be advancing the ball, so we're working on things that won't be quite as much of a heavy lift, both in terms of our organizing or from the election administrators. So we're working on pre-registration of 16 and 17-year-olds, expanding our suffrage at 17 bill that allows 17-year-olds to vote in the primary if they'll be 18 by the general election, to consolidate elections in all elections. We're working to improve online voter registration, and we're working to bring greater language access protections beyond Section 203 to Illinois. So I'm happy to talk about any of that, the amendment we passed, et cetera. Questions?
So thanks. These are all really interesting case studies, and I think there are a lot of themes that come out of all of these, even though you're all working in very different parts of the country. I think one theme that I thought was interesting that a lot of you all talked about was the follow-up work that's required. You know, you do all of this work, you get this great reform passed, and then you just have more and more work to do afterwards to make sure it's implemented properly. And I'll open this question up to anyone. Knowing what you know now about the follow-up work that was required for these various reforms that you got passed or that you got through, is there anything you would do differently, or how do you approach your next challenge? How is your next challenge informed by that experience of doing all this work to get something passed and then doing, you know, even more work to make sure that it's implemented properly? Kathy, do you want to start?
I think that this is applicable to all of the changes that we pushed for, but certainly in the redistricting context, the biggest concern is if you achieve some type of change in the process, is it going to really open up the doors for participation in terms of those people who apply to be on the commission or those people who are providing testimony? And I think what we find with redistricting is that it is an esoteric topic, and people do not naturally gravitate to talking about where district lines should be drawn. And so it takes a tremendous investment of resources, particularly to organizations that organize within communities of color or other communities that are not traditionally high participants even in voting, right? To ensure that their voice is represented. So I will say that in California, besides the big campaign to pass the laws, subsequently, it took, I want to say, about $6 million in foundation funding to a lot of different organizations to get them the resources necessary to be able to go out into the community, educate people, get them to be interested in and make the connection between I understand voting, maybe, I have started to think about census, but how is that connected to participating in redistricting? So in California, not by coincidence, it was a huge investment of resources. There were some 30,000 people who put their names initially into the hat to apply to become a commissioner. I will just say that it also happened to coincide with the height of the recession period, so maybe that small stipend was something better than nothing. But the other piece of it was that some 20,000 people stood in line to provide testimony, and it was extremely diverse, but again, entirely through a lot of outreach that was done conscientiously by organizations. And without that, I do fear that if you created alternative voting systems, redistricting systems, you might, without that kind of investment, still see the same populations participating and the same populations taking advantage of the system. And so you could have a reinforcement of those who have political power, even with an alternative redistricting process.
Marissa, I think the follow-up on the implementation of OBL is another really interesting example.
Yeah, well, and there's a couple things with that, because I think Kathay touched on some of it, and as I kind of noted, one thing that I've learned now going through several sessions of the legislative session is I read every bill that we're proposing or every draft I get with an eye. Like, if I didn't really want to do this, like, what wiggle room does this get me? And I really try to approach it with that perspective, so that to the extent that we can be as specific as possible and still get something passed, I think that's really crucial, and something I've certainly learned that's been valuable. I think it is far easier to get funding and to some extent national group involvement in passing a good law, and then there is a lot of foundations and other groups, I think, that are like, okay, we've done our job, we've checked that, and it's a lot harder to get the resources that it takes to really do this unglamorous, unsexy, but really just as vital work. So I think that that's an important point as well. And then I just want to touch briefly with OBR, there's also, I think it is really, especially with our ability that as we're building a coalition and reaching out to so many different folks and kinds of communities, thinking about creative solutions in the implementation process. So one of the things that we were not able to win from the State Board of Elections was we wanted an API, basically, when you go to the OBR site for groups that traditionally do voter registration drives, often their funding is dependent upon showing voter registration drive numbers, and so they wanted to be able to collect some of that basic information that they generally take off of voter registration card when doing it on paper, and to be able to kind of collect some of that information and then send the registrations through to the State Board of Elections, which is done for online voter registration in other states. We were told that they would absolutely not allow that, and some creative former coalition members have developed the technology so that we are actually just doing that without it being something officially provided by the state, that they've created a tool so that we can get people to register through the organizations and then pass that information on. And so I think trying to think kind of outside the box if there's something that we can provide. And that's been true with a lot of these implementations as well. Just say there's plenty of things that we think it should be incumbent upon the government to provide this service or do this thing, but if that's simply not going to happen, how can we as community groups do that?
Thanks. Earlier today, someone asked a question about what role public shaming has with the litigation, and I thought that was a great question, and I wanted to ask that question here as well, as sort of what role public shaming has had in the state advocacy you've been doing. Bret, I have a feeling you probably have something to offer on this.
Thanks. Yeah, actually, it was another litigation that I didn't mention, Brooks-Gant, which was to force Pine Ridge or the political jurisdictions to offer a satellite office in the 2012 elections. We had success getting them to do it somewhat voluntarily, and then in 2010, through a fairly unstructured and pretty robust political process of a fairly hot-blooded county commission meeting, got them to agree to provide 20 days in 2010. But 2012, one of our associates made a request on behalf of some tribal members on the Pine Ridge Indian Reservation for full equality. And the response by the state and Fall River County and Shannon County was, well, we'll give you 6 days. And out of a 46-day period, that resulted in dropping a federal court action. They capitulated to avoid a preliminary injunction, agreed to provide full equality for the 2012 elections. And as that case matured, they ultimately agreed to do everything through the 2018 elections, and therefore got Judge Schreier in South Dakota to say, yep, now the case is moot because it's no longer right. And the state and the counties then went after the plaintiffs for court costs. Said, we prevailed, so we're going to go after the plaintiffs for court costs. And back to the thesis of public shaming, we then started going, what the heck, or stronger language. Reached out to the county in question and said, where are your minutes by the county commission that you decided to go after these indigent plaintiffs for about $10,000 of court costs? And the county auditor said, well, we didn't do it, we don't know anything about it. And all of a sudden the attorney, who's also the attorney fighting us in Montana and is fighting lawyers committee in the Jackson County case. So there's a firm in South Dakota that specializes in defending these cases. She got on the phone with O.J. Siemens, the executive director of Fort Direction, and said, well, the insurance company insists that we do this. And so well, who's the insurance company? Well, it happened to be a municipally owned public insurance pool of all the municipalities and counties in South Dakota that was the insurance company. So we then went to the insurance executive director and said, did you authorize this? And got funny kind of answers. And then we literally started going to some of the wealthier jurisdictions in the state and said, you need to get your municipal insurance pool that you have officers on under control, because they're fighting these ideological battles because you're paying the big checks, allowing them to do so. Literally got into a back and forth in the public space on this, and ultimately they started showing some shame, if you will, although then Judge Schreier basically laid them out and said, you're not going to go get these court costs. That's insane. You were the reason that they were even in play. So that's one clear example of it. The other, frankly, was on the decision by that election board to say, nope, we're not going to use this federal HAVA money to do this. We had picked the 3 instances carefully, one of which the county seat was 1/100th the size. There was 10 people in the county seat, 1,450 in the Native American capital, and said you ought to have satellite here, so it was a 100-to-1 ratio. In both the other examples, the Native community was bigger than the county seat, so it just made sense. We were actually able to work the media and had the Rapid City Journal, which has never been a friend to Indian country, actually editorializing saying, why aren't we just doing this? So we're able to get, even in a state like South Dakota, the public organs of the media to say, this is nuts, we ought to do it. And we think that certainly laid out the success we had with the Advocacy course, that we weren't perceived as being radical. It was just something that made a lot of common sense. And in a small state like South Dakota, hey, it's a federal money anyway that's going to pay for it. It made it an easy play, but the shaming was that you had these real redneck jurisdictions that just were so bent on not having equal voting rights that it embarrassed some of the other folks in the state that wanted to view themselves as a bit more progressive.
Throw out a quick example also. So in California, despite the fact that we're a blue state, and at the time we had a Democratic Secretary of State, Deborah Bowen, she was incredibly Luddite when it came to making major changes, whether it was same-day registration or online voter registration. It just so happened that in the tail end of her first term, she decided that she was going to run for Congress, which gave us a perfect example or an opportunity to find her at every event that she went to, whether it was a donor event or a public rally, and find opportunities to keep asking her the question, so where do you stand on online voter registration? Why don't you want to save the state money? Why don't you want to have 100% enfranchisement? The best part of it was that it became such a prevalent thing that a lot of people who I didn't realize were invited to these private parties to, potentially open up their checkbooks and give donations, who were our members, would email us and say, hey, I just got invited to this Bowen fundraiser, what should I say? And it was just lovely to be able to tell them, there's one thing that you should ask her about. Ask her what her stance is on online voter registration. Ask her what her stance is on same day, and why do you oppose it? We also did the public shaming, which was working with editorial boards to criticize her administration. But one of the things I think was most deft was to give her a face-saving way out. And that was, she proclaimed herself to be a strong environmentalist. And so we found our good friends at the California League of Conservation Voters to approach her as well, but with a friendly, good cop, bad cop. They were the good cops, right? So here's Common Cause criticizing her in every setting, and then here's CLCV coming in and saying, you know what, we'll stand with you if you would support this. By this time, online voter registration had already made it out of both houses. It was on its way to the governor's desk. The governor has already indicated that he was going to sign it. So it was almost politically no skin off her back. And so she declared, as it was on its way to the governor's desk, that In fact, all along, she had been supportive of these types of changes. And she did it through a CLCV email to say that she was supportive of it for environmental reasons because it would save a lot of paper. So, whatever her reason was and whatever pushed her to that point, you got to be creative about how you get politicians to a place where they do right by the people.
Thank you. I think another thing that we heard was working with unusual allies, sometimes people call them non-traditional allies. So Tram, I wanted to hear from you a little bit more about you both in getting things passed and then also in the follow-up work that we were talking about earlier, work both with Republican and Democrat administrations, sort of lessons you learned from that or your experience in, we're calling you non-traditional allies.
I think if anything we've learned in all of our work is that you can't do this work alone, that you have to bring in whoever you can, whenever you can, to advocate for whatever you need to advocate for. And so, the whole Republican-Democrat thing, I've always said policy wins over politics, and I don't care about party affiliation, whatever, as long as the policy is moving forward in the right direction. So under a Republican administration, building relationships with folks, Republican registrars, Republican State Board of Election folks, just to, we have the same goals, and if you talk about, the implementation aspects of certain initiatives, I think, we get to a place where we can find common ground. I think the public shaming also sort of adds an element of being able to work with other folks, and so, just to go back a little bit on that, the Republican senator that patroned Virginia's photo ID law totally shamed him in every way possible, and even last year when we were doing the rules and regulations, and there was a debate as to whether or not expired IDs would be acceptable, right? And everybody from him on down was like, yeah, there's no point, expired ID is no longer a valid ID, and so therefore you can't use it. And so I wrote this scathing op-ed saying, well, what is the intent of your photo ID law then, sir? If the intent is to prove, a person is who they say they are, then an expiration date has no bearing. And so you go head to head, you turn out folks, you publicly shame them, to a point where this session, he was trying to be my best friend, right? He was like, I don't want her to attack me anymore. He had a bill about pictures on poll books, and
Nice Tram back.
he wanted a nice Tram back, right? And so, I went after one of his bills, and so we amended the heck out of it, and then committee was like, I actually support this bill now. He throws up his hands, and is like, oh my God, Tram supports me. I don't support you, but, and so I think, finding ways to just get people to understand where you're coming from and what it is that you're trying to achieve, whether they're friends or foes, I think it's super, super important. So I think you always have to find whoever you can work with, whenever you can work with them. Your friend is your enemy, is your friend at various times, and that's just the way it all works.
And whether or not you get people to work with you because they like you or because they're afraid of you.
Right, it doesn't matter, as long as the good policy wins out in the end, I think that's critical and important.
So I have lots of other questions for you all, but we don't have unlimited time, so I did want to see if there were questions from everyone else here. We have a microphone. And then I like very much Ari's allowing his panelists to plug what they're doing or ask for help, so I'll give you all the opportunity to do that at the end as well. So, do you want to raise your hand?
Kathy, how is the Redistricting Commission working?
So when it was originally passed, I would say that there was a cloud of controversy over whether or not it was the right thing to do. But I will say that some of our biggest opposition came from Democrats, and since then Nancy Pelosi, who originally organized strong opposition against it, has ordered her congressional Democrats to come up with a national bill that will create national standards for redistricting alternatives, and so she's embraced the idea. I would say that I measure it really by a couple of different factors. One is, did it transform the way that regular folks interact with the redistricting process? And I would say, yes, it absolutely did. When you get 20,000 people coming out to hearings, and I tell you that in decades past, you were lucky to get 15 people in a room to care or talk about their communities. This was, at least at some of the meetings that I went to, people were lined up 2-3 hours beforehand, camped out as if they were lining up for a concert ticket or some football game. You know, it was exciting. I think the other piece of it was that the ultimate outcome of the maps. I think that the commissioners, all 14 of them, very diverse, extremely talented. We had one person who was former Census Bureau chief under 3 different presidents, different administrations, different political parties. We also had a stay-at-home mom from the city of Stockton. So but each one of them took their responsibilities extremely seriously and held 100 hearings, and then ultimately took very seriously drawing maps that would take into account all of this testimony. And I would say that for the most part, the maps that came out are ones where, whether it's political parties or minority communities, that they think that they have a fair shot of seeking the representation that they want. There's certainly, what we built into that initiative was also the ability to make changes along the way, because the reality is you cannot assume that the mousetrap that you built in 2008 or 10 is going to still be relevant, or that there wouldn't be changes by 2020. So we've built in ways for that change to happen in a not as hard manner as trying to pass another initiative, with the thought that this is an evolving process and we have to be responsive to that. It's been popular enough that I find myself now talking to, as I said, about a dozen states who are very interested in seeking redistricting reform. And not all of them are seeking a citizens commission that is divorced from legislative involvement. There are points along the spectrum of what the commission would do and what the legislature's role would be, and even what other elected offices might do. That said, I think that the notion that, as Jason Carter pointed out, we have a serious fundamental problem with partisan gerrymandering. And if we don't create spaces for states to address them in whatever manner the citizens or the legislature figure out, then we are essentially saying we're going to strap voters with this fundamentally unfair system and force you all to pretend that we have a democracy that doesn't give you any choice and that you have no ability to change. So we are very much committed to promoting that experimentation in each state.
Other questions?
I have a question to Tram with regards to the photo ID. Explain that again. There was no requirement. The voter just could walk in and how pretty much the process.
As long as they are registered, as long as they are registered to vote, they sign a form that basically says what's your name, address, and your last 4 socials. They can make sure that you're registered to vote, and you sign it, and they get their picture taken and a photo ID, an official photo ID mailed to them. If they're not registered to vote, then they're given an opportunity to register to vote, and then they take their picture right then and there, and they do 2 in 1. I know, it's insane. It is absolutely insane. It's like you think about it, you're like, well, then what the heck is the point of this, right? But that's what we set out to do. Looking at the bill, the law that was actually passed, and knowing that it didn't have a strong court challenge, we wanted to make sure that we were just basically cutting it out of the meat, you're not gonna have an impact.
Describe what happens on election day?
So on election day, if a voter turns up and doesn't have a photo ID or one on them, one of 2 things can happen. They can vote by an ID-only provisional ballot that allows them 72 hours to show up with an ID, or mail it, fax it, etc. If they don't have one, then they can also just get a free photo ID then and there that same day and use it. And then so what happens is they're issued a temporary photo ID, which is, I kid you not, a black and white printout from, you know, an inkjet photo printer. And they can just turn around and use that 8.5 by 11 piece of paper while they're waiting for their actual ID card to be mailed to them. And so, I mean, it's totally bizarre when you think about it, but hey, it's working right now for us. Until, you know, the state realizes this is so ridiculous that we're spending money on this, that we might not just do this anymore. But yeah, that's how we've been able to try to at least mitigate as much as possible the effects of a restrictive photo ID.
Thank you. I'm asking this question really for a friend, knowing what she would say if she were here, that a few years ago when Georgia began to have computer voting with no printouts, I remember her blustering over and over again, really concerned about fraud, people being able to do it. And there's lots of ways, it's not how which is wonderful, which they do, but how do we really make sure that people don't mess with it, and how do we answer people who will use all of that? It's all going to be fraud, and how do we're in Georgia.
Yeah, that's another bipartisan coalition that exists. The coalition that believes that our voting machines can be tampered with in a way that is systematically going to result in voter fraud. And I say bipartisan because we have folks we have tinfoil hat wearing folks on the Democratic side as well as the Republican side who believe that. I guess the answer to that is, to some extent, there is an administrative solution, which is that the EAC is potentially, the Elections Administration Commission may be reformulating in a way that allows them to be more functional and to adopt a national set of standards around voting systems. And there certainly have been ones that have been languishing for a while that would suggest that there has to be a voter verifiable audit trail. And in the absence of that, many states have adopted voter verifiable paper audit trail requirements so that when you vote, something's printed out, you're verifying it before it's cast. And so there are ways to address this, I guess, both at a federal level and at a state level. Whether or not that addresses people's feelings of conspiracy, it's hard because I guess it's a good thing that they feel that vested in the outcome of an election, and it tends to be that when an election goes a way that feels fundamentally wrong to them, then they believe that it was because of a larger systemic conspiracy. I think that in many states where that voter verifiable paper trail requirement has been implemented, those kinds of concerns at least can be quantifiably addressed, whether or not it changes that person's emotions, that kind of thing.
Yeah, I would say, you know, in Virginia in the 2014 election, there was in the 2nd Congressional District a whole lot of coverage around people's votes being switched. And so it gained bipartisan support. It was a Republican congressional district. Congressman Ridgel was like, oh my gosh, you know, there was a huge news conference. And so it actually led to the governor in his budget amendment this year to include $28 million to basically phase out and purchase new voting equipment for every jurisdiction in Virginia. That would include a paper trail, an audit trail. That didn't pass because, you know, we are in austere times and $28 million is a lot of money. But ultimately what happened, though, was that we did pass some legislation that basically phases out and bans DRE machines. And so whether the state pays for it or locality pays for it at this point, every locality now is going to be phasing out of these, you know, touch screen or DRE machines into either an optical scan or digital scan machine. So, you know, I think that's the trend that I think, as Kathay said, a lot of states are moving into.
Thanks. I think now I'll give all the panelists one final time to have your say. And I would actually, if you all want to, you know, give a plug about what you're working on or what you need help on, that's great. But also one thing that we didn't get to talk about that if you have thoughts on, please feel free to share in this final wrap up is either the effect that Shelby has had on your work in your states or fixes to the Voting Rights Act, the demolition of Section 5, that is. And I know, again, on the panel here, we have a range of people, in states that were not covered by Section 5 or partially covered or fully covered. So any thoughts on those and your final say? And I'll start with Marissa.
Okay. Great, thank you. So as noted, of course, Illinois was not previously covered, but one thing that I think is worth noting that I touched on a little bit is just last year we passed a right to vote amendment, and it better specifies that no one can be denied the right to register to vote or cast a ballot on the basis of and names numerous protected classes. And I think what's interesting to note is it is Illinois, we tend to swing blue, like I said, even though we actually are not incredibly progressive in some of our voting policies and others, and it's a real fight. But things like election day registration came down to highly partisan votes. And if you look at the statewide map, there's a huge divide, basically just Chicago, and that area tends to be more Democratic and liberal, and the rest of the state is very red. And so I think it's just interesting and worth noting that the right to vote amendment actually garnered bipartisan support in our General Assembly. It got about 95% of the House votes, which is very unusual, and a unanimous approval in the Senate. And I think part of that could be attributed to it is worded in a fairly narrow way. Again, it's just about registering to vote and actually casting a ballot, and not necessarily in a way that can kind of be expanded to some of the redistricting and other questions. But it's also just very explicit that it's a voter discrimination provision and that you can't be denied a way in this. What I think did make it, especially with the public shaming and such, really hard for you to explicitly be pro-discrimination. And so that helped us. And what's really notable is throughout the state, which went heavily towards a Republican treasurer, Republican governor, et cetera, this amendment got a lot of support. In fact, there was only 10 out of over 100 jurisdictions where this ballot amendment got less than 50% of the vote. So I think even in states that do tend to be more conservative, that should provide some hope. And then I also just want to obviously emphasize the importance of, we work with the Lawyers Committee, still other groups doing election protection, since there isn't this pre-clearance and being able to monitor election practices. That's really crucial. And one of the things that I did while I still had the Lawyers Committee, the Chicago Lawyers Committee that'll be coming out, is actually interviewing and surveying election officials, and it's amazing that they will sometimes reveal to you that they are doing things that are arguably discriminatory, probably could be litigated against and illegal. And so I think pro bono projects are using your skills as lawyers to actually try to develop, really just reaching out to election officials and seeing what they do, asking for their materials, and it's been quite revealing.
To your point relative to the Shelby decision, certainly some of the areas we've dealt in were covered under Section 5 with Section 4 getting kicked out. We actually think in terms of Native American voting rights and whatnot, we need to get more of Indian country wrapped under Section 5. There's still a whole lot of these jurisdictions that just unless somebody's watching, they will continue to close precincts at will. Something that happened back in 2008, we were working with ACLU at the time. They were going to close all the outlying precincts in Willette County, which is another 50% native county, and have it all be right next to the sheriff's office and the county courthouse on election day itself. And so we think more of those jurisdictions need to come in. In terms of the ongoing work we do, it's one of those things we seem to not be able to get away from. We're certainly going to be reaching out, and again, in Minnesota, to try to make sure that those satellite offices maintain without having to come up with philanthropic dollars always to pay for voting equality, which at a fundamental level we think is insane. And we continue to look for partners, particularly litigation resource partners. The Minnesota thing worked like it did in large measure because we had Lawyers Committee willing to commit the legal resources, because we had worked out the case enough ahead that the facts were there, that before we went in and did that artful, you may face litigation risk discussion with the county attorney, we were pretty certain that we could pull the trigger. In Montana, in the wandering medicine case, we were less nuanced then and just went in and said, we're going to do this, see you in court, and we did. But having those kind of extra partnerships, we think are incredibly important moving forward.
So Virginia was a Section 5 pre-clearance state, so I am very, very sad to see that be gone, because all of our election changes was very easy to just go on the DOJ website, go through the Excel and be like, oh, okay, that jurisdiction tried to do this. And so now we're obviously faced with the huge challenge of monitoring 133 jurisdictions in the Commonwealth, and it's a lot. We worked with a lot of local partners to build a network of volunteers and election protection folks that aren't just protecting the right to vote on election day, but also monitoring things year round. And it's slow going. It's a huge monumental effort, but they've identified some things. For example, Fairfax County in Virginia, 1.1 million residents, in their proposed county budget is cutting our early in-person absentee voting period in half. So, and that would affect hundreds of thousands of voters. And so, identifying these things that we were able to sort of try to advocate. So one of the exciting things that we're working on in Virginia is, expanding our coalition of folks that are looking at voting rights issues and civil rights issues under a broader sort of access to democracy. And so how do we tie in redistricting reform? How do we tie in, election administration or voting suppression? Like all of those things under one umbrella. And then also with access to democracy, we just formed a new coalition this year called Transparency Virginia that interestingly enough has the Tea Party and some very conservative groups as a part of that coalition. And that was born out of, practices in our General Assembly that make it very difficult for citizens to access the process. 6 a.m. committee meetings, 4 hours notices for a bill hearing where, it's just all of this stuff. And so people are sick of it. And so we can connect those issues with this broader access to democracy. Then we've got this huge coalition of untraditional allies that are just talking about democracy in a different way that I think we can then change the conversation about access. And the other thing that we're trying to do is then move this coalition with far right, far left, everything in between, to put some pressure on Congressman Goodlatte. He is the chair of House Judiciary, and his committee will be hearing any bill related to, to reinstating a formula for Section 4, Section 5. And so, trying to figure out if there's a way that we can use this new unholy alliance with the Tea Party to put some pressure on Goodlatte. We'll see. I mean, frankly, I don't know. We can move him, but it's worth a shot, right? And especially now that we've got other folks at the table with us.
I just want to harken back to the fact that several speakers, including our opening speaker, Thomas Hines, reminded us that this is the 50th anniversary year of the Voting Rights Act. And as Ari Berman said, we oftentimes focus on the passage and then treat it as if, okay, done. And what we have to remember is that there are constant efforts to erode those rights that have been hard fought for, and to roll back the voting rights that we thought we had secured in each state. And so if this isn't the year to focus on the Voting Rights Act being not only strengthened but expanded, then I don't know what year is. So we've been talking with a lot of organizations in the civil rights community, issue-based organizations, Planned Parenthood, groups that work in the progressive space to really say that we need to focus on the Voting Rights Act this year. This is our focus. And even though Common Cause is focusing on, we care about campaign finance, and even though I care about, media reform and open internet, the reality is that this is the year to talk about the Voting Rights Act. And this is the year to really focus on some of the changes that will reinstate the parts that have been shaved out by the Supreme Court, but also to strengthen and expand. And I think that some of the innovations that have been happening in the state, we need to ask why not also in our federal legislation. So what I would say is, number one request is look for opportunities to raise this. And I believe in June we've got another anniversary date, so there are opportunities for us to come together collectively and raise that voice very loudly, but also in August, right? So So at each one of these markers in this year, 2015, we have an opportunity to raise this issue again and again. And I think public sentiment is on our side. We shouldn't see that somehow or another, just because people can raise the specter of voter fraud, that we've lost the argument. Because I think the other piece, the countervailing piece of this is that Americans very much do cherish their right to vote. And I think we need to talk about that as a fundamental founding principle of these American states, although not necessarily with the same vision that, when the country was first formed. Second thing that I would say that we should be focusing on is coming to my pet issue, which is redistricting, looking for opportunities to support state efforts to reform their system. And as I said, I think Michigan, I think Virginia, North Carolina, Illinois, Ohio. So Ohio has a ballot initiative that will be on the ballot November 2015 to change and create some greater protections for their redistricting process through an independent commission. I think that we should be supporting those efforts in various states because, again, it elevates the conversation nationally. And the last is, I think, to the extent that there are attorneys who've got time on their hands, because I know you just always have extra time, and you're looking for an interesting case, I think we should be looking to litigate cases that challenge political gerrymandering in blue states. And we've got one that's percolating up in Maryland, but I think that there are others where the gerrymandering that's been done has been done by Democrats. Only just because I think, if I was being crass, that the Supreme Court, at least the 4 or 5 who are controlling a lot of these redistricting cases, might see things a little differently if they saw it as a Democratic gerrymander. And so we have to be strategic about what cases we support and litigate, and we certainly, for Common Cause, would really appreciate any law firms that want to step forward to be part of that pro bono team. Thanks.
I just want to say thanks again to this great panel. I hope everyone took something away from today that you can use in your work, and so thanks again to you all.